Court, all rise. Hey, 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 all present, thank you before the Honorable the Justice of the Appeals Court of Boston. Draw near, draw your attendance, and you shall be heard. Gods in the Commonwealth of Massachusetts, please be seated. This court is now open.
Good morning on this Thursday, January 5th, 2023, and welcome to the Massachusetts Appeals Court. I am Justice Ditkoff. To my right is Justice Singh. To my left is Justice Grant, and we'll be the panel for all 6 cases today. We have all experienced attorneys today, so you know, but I'll go through it anyhow, just for the ritual. You will have 15 minutes for each side. There's no rebuttal in the Massachusetts Appeals Court. The yellow light will go on when we're at 90 seconds, the red light when time is up. You can finish your sentence, but don't continue unless you're answering a question from one of the judges, in which case, please answer the question. And of course, we're not bound by the lights. We can go as long as we'd like. You don't have to take your 15 minutes if you don't want to. We have, I promise you, read the briefs, and we have perused the appendices, so you can get right into your argument. You don't have to give us the background. With all that having been said, we can get going. Our first case is number 22P162, Commonwealth versus Oliver. Counsel, whenever you're ready.
Thank you, Justice Ditkoff, and may it please the court. Good morning. My name is Josh Daniels, and I represent Ms. Oliver. We are asking you to set aside Ms. Oliver's uttering conviction for 2 reasons, both dealing with the knowledge element of that charge. First, the Commonwealth's case-in-chief failed to prove beyond a reasonable doubt her personal knowledge or belief that the check she presented was forged, and that is because it offered no evidence about how she came by it, nor of any suspicious or guilty behavior on her part, requiring the jury to speculate about whether those circumstances would have alerted her to the forgery. The second reason is that even if the Commonwealth's case sufficed, the judge created a substantial risk of a miscarriage of justice by failing to instruct and explain what the knowledge element really turns on, which is her personal subjective belief, irrespective of whether that belief was objectively reasonable. Beginning with sufficiency, in essence, the Commonwealth has proceeded in this case as though proof that she cashed the check and that it was forged automatically sufficed to prove her knowledge of the forgery, and that just cannot be right, because if it were, it would effectively render the knowledge element superfluous of the other elements of uttering. Here, I think, taken in the Commonwealth's best light, their case showed the following. Ms. Oliver cashed the check at issue. Mrs. Mahoney did not write the check and did not know Miss Oliver. Some other person, Larry Sanchez, stole and enhanced 1 or more of Mrs. Mahoney's checks. There is no evidence that Miss Oliver had any connection at all to Miss Sanchez, and we don't even know what enhanced means. I would also note that I think a key thing to keep in mind about this case is that the fact that Mrs. Mahoney was unfamiliar with Miss Oliver doesn't really tell us very much about who Miss Oliver may have gotten the check from, or how she knew that person, or whether their circumstances would have alerted her to the forgery. And so I take some issue with the way that the Commonwealth framed the first question presented in its brief, because I don't think you can necessarily infer that Miss Oliver had a check from a person she did not know. We can infer at most that she didn't have a check from Miss Mahoney, but that still doesn't, for example, make less plausible the alternative innocent possibility that was available from the Commonwealth's case in chief. That, for example, she could have gotten the check from an imposter claiming to be Mrs. Mahoney. Perhaps it was for a used car. Again, I'm focused only on the Commonwealth's case in chief, so under Blow, we don't look at the defense case. We're just looking at whether the motion should have been denied or allowed when the Commonwealth rested.
But getting to the issue of the element that you say is missing,
yes,
which is her knowledge, You agree that that must be proven through inferences?
Most of the time, it must be, because direct evidence isn't always available. There are some cases in which it could be available through admissions. For example, I think Pacheco, that the Commonwealth cites, gets a little bit close to that, because there were statements by the defendant that I think fairly spoke to the defendant's knowledge that the checks were not authorized in that case. But often I think how the gap gets filled circumstantially in these cases, and if you look at the cases that the Commonwealth cites, it's often through suspicious or guilty behavior on the part of the person presenting the check. So, for example, in Catania, there were lots of these circumstances. They were trying to cash checks at different banks around town. They refused inquiries when the bank came inquiring. Sometimes they refuse inquiries when the cop comes inquiring to investigate. And in Catania, I think especially, is the fact that the defendant immediately tried to get more money after the bank called to report that they had discovered.
What do we do with the fact that she denies looking at the check, but yet she just happens to go to a Salem 5 bank, and that's the bank it's drawn on?
So I think as to the fact that she denies looking at the check, we actually don't consider that fact, because, again, we are focused on the Commonwealth's
Okay, but
case
in the
chief.
Commonwealth's case in chief, there was evidence that she went into a Salem 5 bank and cashed a check that was drawn on Salem 5 Bank with the name Eileen spelled wrong for $3,600. Couldn't the jury infer from that she knew that the real Eileen didn't sign the check?
I don't think so, because first of all, we're assuming that she noticed that Eileen was spelled wrong. The bank teller didn't even notice. And so I don't think it's a reasonable inference that she likely saw that, if even the bank teller, who is paid to look at these things and to check the signature card, didn't even notice. And second, cashing a check at the bank on which it is drawn is a perfectly appropriate way of getting money. It's recommended by personal finance advice people to ensure that the check will.
Does it create an inference that the person who cashed it looked at the check?
I mean, looked at the check, but that doesn't tell us anything about how she got the check or who she got the check from. I think. So the problem with this case is, without any suspicious or guilty behavior, what we are left with is we need to, in order to get to the inference of guilty knowledge, I think we need to pile inferences atop each other in an inappropriate way. We may be able to infer, I think we can infer probably, that the check, either an original or a convincing facsimile, somehow made its way from Mrs. Mahoney's checkbook into Miss Oliver's hands. But we have no idea how that happened, and we'd need a leap of conjecture, in the language of the cases, to infer that whatever those circumstances were, they bestowed guilty knowledge on her. Again, turning to the cases that the Commonwealth cites and the kind of behavior that fills that gap. In Pacheco, he admitted that he got the check from somebody who came in to have car work done, and that person paid him with a stranger's checkbook. That's really weird. It's far weirder than simply cashing a check at the bank on which it is drawn, which is perfectly appropriate. And again, for all the Commonwealth's evidence showed when it rested.
I don't see why we don't have that here. She's never met Eileen Mahoney, so she's got a check written by a stranger to herself that she's trying to cash.
I think it's equally plausible on these facts taken in the Commonwealth's best light, and again, looking only at its evidence, that she got the check from an imposter claiming to be Eileen Mahoney, unaware of either the ID theft or the forgery. ID theft is sadly
Maybe a jury could infer that she got it from an imposter, but why do they have to infer that?
They don't have to, but when the Commonwealth's case taken in its best light supports either of two equally supports either of two inconsistent possibilities, the evidence is insufficient. That is a principle that the Supreme Judicial Court reaffirmed as recently as 2020 in Tavares. And so I think that evidence is not proof beyond a reasonable doubt of the knowledge element if the evidence is in equipoise, taken in the Commonwealth's best light, and it is. I do want to briefly note or stress something that I raised in my reply brief, which is the theory that Ms. Oliver personally committed the forgery was never presented to the jury below, and so I think under Dunn versus United States, it can't properly be a basis to uphold the conviction.
Well, I don't understand that. Why, when the judge is ruling on the motion for required finding of not guilty at the end of the Commonwealth's case, is he required to exclude a theory because later the Commonwealth won't argue that in its close? How's that supposed to work?
I think the language of Dunn that I am relying on is that it violates due process to uphold a conviction on a charge that was neither alleged in the indictment or the complaint, or presented to a jury at trial. And here the Commonwealth did not charge her with forgery and never hinted in it, never so much as hinted in any of its evidence that she was the forger. It did not do so in its opening, it did not do so in its closing, and so the Commonwealth is stuck with the theories that it presented below.
But in order to prove uttering, you have to prove knowledge that it's forged.
Yes.
So it sounds like you're saying, you know, at a receiving stolen property trial, the Commonwealth wouldn't be allowed to introduce any evidence that the defendant actually stole the property.
No, I'm not saying that. I'm saying if that's not the theory that the Commonwealth presents at trial, in the trial court, then they cannot on appeal assert that theory as a way to salvage the conviction. That is what I am saying, and they did not present that theory here. Unless there are any other questions about sufficiency, I think this might be a good time. Well, before I do that, the other fallback position I have is even if you don't buy my argument from Dunn versus United States, I think there's still the question of whether these two signatures that have so little in common in terms of their content, there's just a scattering of letters that are not in the same context between the two, could be whether a reasonable fact finder could look at those two and conclude beyond a reasonable doubt that the same person made both of them. I don't think I've ever seen a case that says that has held that. I don't think O'Connell is such a case for the reasons I've said in my brief. I think if there are no further questions now, I would like to turn to the jury instruction issue that I've presented. And the problem that we see in these instructions is that they do not explain anywhere that the knowledge required is actual and not constructive. In other words, what the jury had to find here was that Ms. Oliver personally, subjectively knew or believed the check to be false or forged, not simply that some reasonable person in her shoes confronting the facts.
The jury found that she had the specific intent to defraud. So how could they find that without also finding that she personally knew that it was forged?
I think the intent to defraud and the knowledge elements for the reasons that I say in a footnote in my opening brief, they sort of go together. They either rise or fall together. I think if you don't know that it's
That's
forged,
what I think, but that makes me think that the jury must have found, whether or not they could have found, we've just talked about, but they must have found that she personally knew about the forgery, otherwise they couldn't find the specific intent.
But they were never instructed that the knowledge has to be personal. That is our quibble with the judge's instructions or complaint about the judge's instructions. And so that left them materially incomplete because it's not, the law of knowledge here is not simply that they can convict her if they think that she should have known based on what she was confronting, that a reasonable person would have known that this is forged. It's that they have to believe that she personally, subjectively had that belief, irrespective of whether that belief was reasonable. We acknowledge that this is a substantial risk case because there was no objection or request for the instruction, but there are a couple of things to stress here. One is that cases recognize that instructional defects about the essential elements are inherently prone to substantial risk because they go to the very definition of the crime. Another is that this knowledge in this case was not just the heart of the case, it was the entire case.
But the language that was used by the court was that the jurors had to found that she knew, not that a reasonable person would know, right?
Right.
So what was wrong with the language there? Isn't that exactly what you're suggesting should have been done?
I'm saying that the judge should have read that second paragraph from 3140, which is incorporated by reference in the uttering instruction, that says, that emphasizes that the knowledge has to be personal and it does not turn on what a reasonable person would have thought in this circumstance. I think without that instruction, there's a real risk that, again, the jury might have thought, well, you know, if any reasonable person were there, they would have known. So I don't really care whether she knew. She should have known. And that's not the definition of the crime that she was charged with. The other thing I would just note is, although it's not a perfect analogy, I think that Taranovsky is a really helpful case here, because in that case, again, you were dealing with a model instruction that failed to explain a material element. It wasn't the fault of it wasn't anyone's fault really, because this was a pre-Maguire model instruction, and so the SJC came out with a clarification that that element is more nuanced than people perhaps appreciated at the time. But what this court held was the failure to provide that explanation rendered the instructions materially incomplete, because the distinction between objective and subjective mental states is not self-evident or obvious, and it's one that jurors need to be told about. And so I think, while not a perfect analogy, it is a good analogy for this case. Seeing that I have 14 seconds left, if there are no further questions, I'm happy to rest on my brief.
Thank you very much, Counselor. Very helpful. We'll hear from the Commonwealth now, whenever you're ready.
Thank you, Your Honors. Good morning, and may it please the Court. ADA Lindsay Russell for Middlesex on behalf of the Commonwealth. Turning first to the sufficiency issue, at the close of the Commonwealth's case, there was in fact sufficient evidence beyond a reasonable doubt permitting the jurors to find the defendant had knowledge that the forged check she presented to be cashed was in fact forged. Those factors that were before the jury were, number one, that the victim and the defendant were strangers. The victim, whose name was on the check as being the account holder for which the money would be drawn, testified that she did not know the defendant. Accordingly, there was no reason for the defendant to believe that she was owed thousands of dollars from the account of someone that she did not know. And that knowledge of each other would go both ways. If the jury believed her testimony that she did not know the victim, that the defendant, then therefore the defendant also did not know the victim. Secondly, the fact that the defendant cashed this large amount of money, and again it was $3,600, instead of depositing it into an account where, if the check had bounced or it was later determined to be fraudulent, the bank would have recourse and could of course take the money.
How do we know that? I didn't see that. I might be missing it, but I couldn't see how we knew that she walked out with cash.
I don't think we can see it in the surveillance footage, but I believe the testimony of the bank employee talks about the cash.
They talk about her cashing a check, but of course, right. I mean, I went and cashed some checks yesterday, and I put them in the accounts. I mean, that's kind of a word that doesn't mean necessarily you get cash.
I would suggest that cash would mean that she was getting cash for the check. Otherwise, it would be depositing the money into an account. I think it came out in the testimony as well that she did not have an account there. She did present her ID and everything, and the bank employee wrote that information on the back of the check. But I believe the testimony came out as evidence that it was cashed. And in any event, again, this is just one of the factors that leads to the sufficiency of the knowledge element here. Justice Grant earlier mentioned the fact that the defendant went to the bank on which the check was drawn. Clearly, she had taken a look at that check. Or at least that's the reasonable inference that we can draw from that. A third factor here that the jury was free to find is, as my brother mentioned, that I mentioned in our brief, the inference that the defendant herself forged the check. Now, it's true that the prosecutor during the trial did not make this argument explicitly, but it was certainly a reasonable inference that was before the jury, given that the check was before them, with both the defendant's undisputed signature on the endorsement on the back.
Well, I'm looking at the check and the back right now. And can you tell me how I can tell the same person wrote Eileen Mahoney and Dominic Oliver? Because what similarities are there between those two signatures?
Well,
that
again,
would
I'm
allow-
not sure that we should actually be putting ourselves, substituting
Okay.
judgment here.
What similarities would allow a reasonable juror to determine?
All right, I would
If
say
they
the
were the same.
flourishment in the signatures of the D on the, so the back of the check is obviously undisputed that that's the defendant's signature.
Yep.
That D, it's very flourished as well. And then if you look at the E, the Eileen on the front of the check, I would suggest that that's flourished. The M, obviously, it's different to compare the forged signature to Eileen's normal signature, but there's clearly a big difference in terms of the flourishment there that I believe Dominique, the defendant, has in her signature. I would also mention that the RMV image, along with the defendant's signature that goes with that, was also entered into evidence. So the jury here actually had two samples of the defendant's signature, both on the back of the check and on the RMV image. And I would suggest that while it's a smaller signature in the RMV image, that D, that large flourishment is still there that I think corresponds with the forged signature on the front as well. I would also suggest that the timing of the check, that was also something that was before the jury. And again, not something explicitly made clear by the prosecutor, but all the dates and everything on these checks, as well as the fact that the defendant entered Salem 5 Bank on January 19th, 2019, was before the jury. The victim here testified that she believes that this Leary Sanchez, who's the other home health aide in this case, that she believes that a check was stolen from her in early 2019. And my brother mentions a lot of case law surrounding receiving stolen property, which I think is properly analogous area of the case law. And in the jury instructions there, they allow what's called a permissive inference, that the defendant had knowledge of the unauthorized nature of stolen goods, depending on the recency with which the defendant possessed those goods. And it's explicit in that instruction that the jury may infer the defendant knew the goods were stolen if the Commonwealth proves the defendant possessed recently stolen goods. Also in that instruction, it states that such an inference may itself support a finding of knowledge beyond a reasonable doubt. And here again, we don't just have this. We have the fact that they were strangers, which I think really is the most important factor. We have, I would suggest, this large amount of money that is cashed rather than deposited, the recency, and again, I think that you can make that reasonable inference based on the handwriting that this was forged by the defendant herself. If there are no further questions on the first issue, I'll turn to the issue about the supplemental jury instruction. So with respect to the supplemental instruction, knowledge, not only did the trial counsel, never ask for this instruction, but there was no substantial risk in the court not giving it sua sponte. The missing element cases that the defendant brings up, Taranovsky, Hill, they're just very distinguishable from this. This isn't a missing element case. The judge read the model instructions for uttering verbatim. And as Justice Singh pointed out, those instructions are actually very explicit in the third element there that the jury must come to the conclusion that the defendant knew the check was forged. It doesn't say that the defendant should have known or that a reasonable person in the defendant's situation would know. It's that the defendant knew. In Taranovsky, the SJC added an entire other element earlier to Taranovsky's case that was required to be read to the jury with respect to open and gross lewdness, and that was that there was both a subjective and objective element when it came to the shock and alarm portion of that charge. The judge in that case only gave the subjective element as an instruction. Here, we only have the subjective element, and it's clear from the instruction, again, which the judge read verbatim, that that was what was instructed to the jury. I would suggest that in the prosecutor's closing, she was essentially encouraging the jury to use their common sense and daily life experience and again, to just draw those reasonable inferences based on all the evidence and facts presented to find that the defendant did in fact have knowledge of the forged nature of this check. And if there are no further questions, I would rest on my brief.
Thank you very much, Counselor. Thank you both. This has been...
One point of order. The permissive inference law was not briefed
Well, if you want to do a Rule 22 letter, you can, but we don't do rebuttal. You can use the Rule 22 process to bring any point you'd like. Thank you both. This was really helpful, really interesting case, and really well briefed. Ms. Paris, we okay? Okay. All right, I will call the second case, 22P616, Commonwealth versus LAGOTIC. And this one, we'll first hear from the prosecutor. Oh, I see you sat the wrong desk.
Exactly.
I understand the
That's my first
mistake.
time, Mr. Commonwealth. Yeah. May it please the court, ADA Chichely for Middlesex on behalf of the Commonwealth. The trial judge made an error when he allowed the defendant's motion for required finding based on operation after the jury returned a guilty verdict. The evidence was more than sufficient to prove the operation. The defendant made repeated mission statements to the officer when the officer asked, "No, are you injured because of the accident?" He said, "I'm fine." When asked how he crashed, he explained how he crashed coming from the on-ramp, he hit the snow, lost tractions, and went into the woods. When asked where he was coming from, he explained that he came from Belmont, ended up in Acton. He stopped for drinks and foods. And at the police station, he explained that he had a concussion, which is consistent with the deployed airbags in the vehicle. He also told the paramedics that he was going 60 to 70 miles per hour. And these statements were also corroborated by a lot of other factors in the case, where the tire marks and fresh snow tracks shows the recency of where the vehicle was driven. The defendant submitted to field sobriety test, which he did not complete successfully. Everything in the case suggested that the defendant was the one operating the black Camry in the case, and the evidence was more than sufficient to prove operation. If there are no further questions, the Commonwealth sounds brief.
Oh, you got it? Well, I do have a question then. I'm sorry, I thought you were still ramping up. You cite Leonard, but you don't discuss it. And I'd like to hear your best distinguishing of Commonwealth versus Leonard.
Leonard, yes.
That was the husband and wife OUI case.
Yes. So in Leonard, there was the only evidence from the Commonwealth's case in Leonard was the defendant admitted to two witnesses saying he was the one operating. The testimony from the wife was she was the one driving the car, and it was testimony about yelling who should get a key. So in that case, if you look at the case, the only evidence the Commonwealth had was the defendant's statement. There was nothing to support the defendant's admission. In this case, there was no one else in the car that could have been driven the car, and that's the one key factor, that's major factor from Leonard. And there's another case about the court found insufficient was Mullen, and it's the two major cases the court has found insufficient for operation. In that case, a person was stuck in the car, and the defendant was ejected from the passenger seat of that car. So this court in 1975 say that shows more likely than not that the defendant was the one in the passenger seat, and there's nothing else to suggest the defendant who was ejected from the passenger seat was the one operating the car. So these two cases are very different from what we have here. And if the court look at Proya, which is a 2020 case from this court, in that case, the car was registered to the defendant, the car was left on a snowbank. The only other evidence was the defendant was located nearby, and his appearance was consistent with someone involved in a crash and walking the snow. This case is more than Proya, where the defendant admitted to operation multiple times, where everything on scene suggested the defendant was the one operating the vehicle. This case is wildly different from all the cases the court had found insufficient for operation.
All right.
No further questions. The Commonwealth stands brief.
Thank you very much.
Thank you.
We'll hear it from defense counsel whenever you're ready.
Thank you, Your Honor. May it please the court, Sean Gallagher on behalf of Mr. LAGOTIC. I agree with my brother that the issue is a narrow one. I'd like to point out a couple of points in response to some of the main arguments made by the Commonwealth. The Commonwealth indicates there are 6 criteria that a court should look at on the issue of operation. The first one is whether the vehicle had recently been involved in a collision. there was no evidence of collision in this case. Car slid off the road. So I submit that part is not relevant. The interesting part is whether or not it was recently involved in sliding off the road. The evidence as to that is the officer testified that the tracks were fresh, as to the tire tracks. My argument with regard to that is you can't deduce recent from fresh. It was a clear night. There was no indication of precipitation or anything that would affect the tracks and how they looked. And I think a reasonable person could look at a tire track in the snow and say, well, fresh doesn't mean an hour. Can it look fresh after an hour? Can it look fresh after 2 hours? If there's nothing that affects that track and the weather is such as it is on this night, I'd submit to the court that the track could be there for an hour, 2 hours, 3 hours, and still reasonably appear to be fresh. So that's my point with regard to that.
Where does that go, though? I mean, it's 1:42 a.m. and we're 100 feet into the woods.
The big thing, I think, in the defendant's favor in this case is the time frame. The Commonwealth can't establish a time frame between when the car slid off the road and when the police arrived at the scene. In a number of cases, and I think they're in my brief and perhaps in the Commonwealth's brief as well, is one key factor is, well, the police got there right away. And when they get there right away, they see witnesses at the scene, they're tending to the person who's ultimately determined to be the driver. So in those cases, as is noted as a factor here, recency is an important consideration as to whether or not the Commonwealth made out its case in a light most favorable to them. But still, once you do that, you still have to get to the hurdle of beyond a reasonable doubt. So once you get through the Lattimore lens, that beyond a reasonable doubt is still there. Another point made by the Commonwealth is the defendant's presence at the scene. Well, that's been discussed, and I'll concede at the scene. There was a distance of maybe 100 feet or something like that, and his demeanor. And again, there's cases that cite, and the Commonwealth cites them, that a person's demeanor is evidence, or maybe evidence, of operation. And what they talk about in those cases is, well, the person was really shaken. And one officer said, this person was shaken as if he, or like a person who had just been in an accident. So that doesn't cut the Commonwealth's way either. There was no evidence that he was shaken.
I thought he said that he thought he had a concussion.
Well, that's what he said back at the station. And that's a statement was made, but without any attendant factors that would indicate in any way that he was actually shaken by an accident. And certainly at the scene would have been the most recent time between the accident and how the defendant looked. And at that point in time, there was no indication that he was shaken at all. So that's how I would address that point. Another interesting...
But so we're to take the statement, I think I might have a concussion as having nothing to do with what happened roadside? It's just
I can't say that, but
coincidentally, he thinks he has a concussion?
But one of the interesting things in this case is that there are two airbags in the front, and they both deployed. And if you want to get back to possibly reasonable, inconsistent inference to draw from the evidence, is that, well, he could have been the passenger as well. There's an airbag there, there's an airbag there, they both deployed.
Do you know if airbags only deploy if there's somebody sitting in the seat?
I don't know the answer to that, but it did deploy. So it did deploy, so if a person was sitting in the seat...
Wait, where's that evidence? That they both deployed?
It's definitely in the transcript, Judge, that both airbags deployed. And I know it's in my brief. It may be in the Commonwealth's brief as well. This is an interesting point, too, I'd suggest. They talk about the person doing the field sobriety test, and apparently without objection. So my point was that, and I cite Van Houten on this point, you have a cruiser come to the scene with however many lights activated. You have an officer, they say, in full uniform, so you assume uniform, badge, gun. And the whole thing is designed so that the subject of the officer's inquiry knows that he is wholly subservient to the officer. He's in that uniform, he's got that cruiser, he's got that gun. And in Van Hooven, they talk about compulsion in the officer asking a person to do field sobriety tests. And what they said there, that it wasn't sufficient compulsion in the context of a Fifth Amendment right. What I took from that is, well, if it's not, they didn't say it was no compulsion. They said it wasn't sufficient compulsion. So there's an element of coercion when an officer, dressed as he is, asks a person to do field sobriety tests. And the other part of that is the person who gets asked that question, he doesn't know what his fate will be. The officer doesn't tell him you don't have to take the test. The officer doesn't tell him, hey, this is what might happen depending on the test. So a reasonable person could say, well, I'm in this situation. I don't know what's going to happen if I don't take the test. I'll take the test and take it from there, whether I'm the driver or not. And why should I be giving this guy here any tough time? Because that's not going to be down to my benefit, and that's for certain. There's also lack of bystander evidence. They use that in the cases. Lack of bystander reaction to how the officer is treating the subject. And the lack of bystander reaction, basically the inference is drawn from that the people there know that this guy was the driver, and they're not objecting, hey, you shouldn't be doing that guy because he wasn't the driver. And in this case, it's not applicable because there are no bystanders there. Of course...
Well, the officer testified that he went to the scene in response to a call and that there was light traffic on the road. Can we infer from that the call came from a passerby?
I think that would be a fair inference that it did come from somebody who was driving by.
Well, then can we infer from that the car wouldn't have been there very long before a passerby called?
I don't believe so because there's no evidence in the record as to when the call was made. So I wouldn't think so. And in the context of how the witnesses who happen to be there react, obviously if the passerby is not a witness and there's no evidence, well, a witness is something, but no witness as to what the interaction between the police and the defendant was at the scene. The Commonwealth relies on three cases fundamentally. And I go through it in my brief, and I'd submit there's material distinctions between each one of those three and the facts at bar. Of course, I understand that the corroboration, the bar is not that high, but it has to be more than scant corroboration. And in this case, I'd submit there's no more than scant corroboration. And one of the interesting things, I think, is that the Commonwealth cited no case as controlling or dispositive. And that in and of itself, I'd suggest to the court, really, this is a case that the court should really chew on before coming to a determination. I would think that if the Commonwealth had a dispositive case or a controlling case, they certainly would have made it known to the court. The flip side of that is I don't have one either, but it's not my burden. So I'd say that. And one last thing on that Mullen case that was mentioned, a lot in the Commonwealth's brief talks about the court should not have entertained an absence of evidence in arriving at its conclusion. But I think courts do that all the time. You have cases with the same issue, and you have cases on one side and cases on the other side, and you compare and contrast, and you look at what is absent there. I think that's done all the time, and that was done in Mullen by the court. They found that there was not a basis for a finding of guilt, and one of the points the court made was that you have this accident, and you have two persons by the vehicle, one actually in some way trapped within the vehicle, and the Commonwealth brought in no expert testimony on whether or not they could look at the injuries and how those are, and then work backwards from those as to which person was in the car where at the time of the accident. So that's a case where the court directly stated in its opinion, we're concerned with an absence of evidence here. And I think it was appropriate for the trial court to also take that tact in looking at the evidence. I have nothing else to offer.
All right, well, thank you very much, both of you.
Thank you.
It's an interesting case, and we're grateful for your assistance. Weird. All right, I'll call the third case, 21P 957, Commonwealth versus ROCHA. Counsel, whenever you're ready.
Good morning, Your Honors. May it please the Court, my name is Valerie De Palma. I represent the defendant, Matthew Rocha. In this case, the judge improperly found that Mr. Rocha violated his probation by assaulting and battering his girlfriend, Rebecca Levesque. The evidence that she relied upon was the 911 call statements of Nicole Alf, who was my client's girlfriend's friend. And the call, she was in North Carolina at the time she made the 911 call. Excuse me. In her statements to 911, Alf repeated Levesque's statements to her that Rocha had assaulted her. This double hearsay lacked substantial indicia of reliability, and therefore the judge erred when she relied upon it. Double hearsay is admissible in probation violation hearings, but it either must fit within an exception to the hearsay rule, or it must display substantial indicia of reliability under the SJC's Hartfield case. Here, Ms. Ol's statements don't fit within any hearsay exceptions because she lacked personal knowledge of the incident. She was not present. Furthermore, when considered under the factors in Hartfield, her oral, unsworn statements lacked reliability, such that they were not a proper basis to ground the probation violation finding.
What about the fact that she identifies herself, gives all her personal details to the police? It's made to a 911, I'm sorry, it's made to the police, and she's identified herself. Doesn't that add?
I would argue no, Your Honor. It's similar. Her self-identification and presumably hearing the call was recorded are like sort of the factual detail, in the sense that they do not in any way rectify her lack of personal knowledge. I mean,
Well, she doesn't have any personal knowledge. She's heard some excited utterances.
she has personal knowledge of those statements, yes.
Right,
But-
well, so she says that she gets a call from her friend who's hiding in a cranberry truck. This is like February, and lo and behold, there's her friend in the cranberry truck. Why doesn't that corroborate that she's actually gotten a call from the friend?
How should I state this? What we're seeking corroboration of is the fact of the assault.
Are we, though? I mean, because, I know you don't think it's an excited utterance, but if it is an excited utterance from the victim to Ulf, then all we need to get from Ulf to the end is that her reporting of the excited utterances is accurate.
I would disagree, Your Honor, because it's sort of like, I was trying to think of an analogy, and use the telephone analogy with hearsay, right, the further back, you know, in terms of degrees of separation. But I guess maybe the one that, and it's imperfect, is like, it was like a short circuit. The problem is, if all of it had come in and testified, there would be no problem, because she would be testifying concerning hearing the excited utterance and the conditions of it and so forth. It would be like, I mean, these cases typically present themselves as 911 call, police officer arrives, victim is there, victim makes excited utterances, and frequently the victim does not cooperate with the prosecution, police officer comes in, and again, in the probation violation context, I'm speaking, and testifies to the excited utterances, and therefore the evidence is sufficient because it's, you know, we would understand the contours of that connection. But here, Ms. Olf was, you know, what was presented to the court was her the 911 call, which I just wanted to mention. I have before the court a motion to file a supplemental record appendix in which I included a CD of the 911 call itself.
You're about to file that, or you have filed it? I haven't.
I did. It's pending, and it said it was referred to the panel on the docket.
I'm sorry, I missed that.
Yeah, I filed it when I realized that the exhibits don't automatically come here. I had come to the court when
When did you file that?
I have it on December 14th.
Keep going.
Okay, so I just
I'll
want to
figure
make
this out.
sure, just to point that out, that the CD is.
Good, you did.
The problem here is that she did not appear in court.
Well, let me ask you something. Let's assume that Olf was a vindictive person. She made this whole thing up. She doesn't like the fact that the victim is dating this guy, so she made this up and called the police from North Carolina. But she gave her name. So isn't that, as Judge Singh was saying, what makes her reliable? If she's making a false report of a crime, the police can track her down.
True, I agree. It goes to her personal, it's sort of, I guess, going back to if you want to do an Aguilar-Spinelli analysis, right? It goes to her track record or her sort of something that she has skin in the game.
She's not a confidential informant, in fact.
True. No, she's a named informant. And, but I still would argue if you were doing an Aguilar-Spinelli analysis of this, those facts would relate to her reliability versus basis of knowledge. And what she is, the corroboration, I just would like to get back to the personal, point that she has no personal knowledge. She was not there.
I have a question for you on that. So Hartfield says it's whether the evidence is based on personal knowledge and or direct observation.
Yes.
So are you saying that Olf that means visual observation, or can it be heard observation,
True. Yeah, I think it could be heard, but the only evidence during the call, she states she heard, there was at one point an allegation that Rocha threatened to kill, she overheard him threatening to kill the victim. However, the judge
disregarded
declined it because it wasn't clear, she didn't know Rocha personally, so she couldn't have identified his voice. But also, she just couldn't determine what that was the basis of. I think, for instance, in that Ella Contra case where it involved a home invasion and the child in the house ran over to a neighbor's house and so the neighbor calls 911 and the child is standing there and saying, a guy broke into screaming and crying, and I can't remember if he was bleeding because he was also attacked by the defendant. And so she calls 911 and she says, she starts making, statements about, and at one point she says, a guy broke into the house, and the SJC was confronted with whether these, it found most of her statements to be excited utterances, but it did find that, well, she couldn't have had any direct knowledge about the guy because she wasn't present during the crime. And so the question was whether that was, they could consider it as a, and ultimately they did find it was, but I think the context there was that the child was with her and making statements while she was on the phone. And that just simply isn't present here. And the problem is, I guess personal knowledge, I didn't know this, is that this requirement is older than the hearsay rule. You can't be a witness. You can't be a hearsay declarant unless you have personal knowledge. It's the linchpin of reliability, and it what prevents rumor from being, admitted as substantive evidence. And I think here, yes, there was corroboration of certain details, but including her injuries. However, those do not corroborate. There's no causal link between those injuries and my client's, conduct. Yes, and there's one case, well, this was, I have to say, I searched and searched. I found no Massachusetts probation violation cases where this issue was sort of, because it's unusual. As I said, it's an unusual fact pattern, because these cases typically present as the police.
I'm not sure I understand what you're saying about the causation. Like in a normal case, the police hear the 911 call, they come and they see injuries on the victim. They didn't see the defendant inflict them.
Right.
Is that not what causal means? I'm not following the causal thing you're saying.
Well, what I'm saying is that they see them, and typically in the typical case, the victim makes excited utterances that the defendant assaulted her. What's different here is they get there and she says, no, he didn't assault me.
But you're saying the circumstances aren't sufficient to draw the inference?
Well, there's nothing from which to draw an inference that my client was the person who assaulted her. The only case, again, that I found was from the Eighth Circuit, U.S. versus Coleman, which is cited in my reply brief. But it was somewhat similarly presented, except that the victim went to the police 2 days later. And the police, they go to the hearing and the police testify, and they testify to the woman's injuries. And they said, and they took photographs similarly as here, and the court said, even though the injuries correspond to the statements that were the victim's statements, there was no non-hearsay evidence answering the who, what, when, and how behind the injuries.
Is that a probation case?
It is. It's a probation revocation in federal court, which, but as I said, I think that's what defense counsel was trying to argue below. And
What about the circumstantial evidence of how she's looking back at the house?
Well, I think her nervousness, yes, that's there, but I just don't think that it's sufficient to draw the,
Statements associated with that as well. It wasn't simply looking back at the house, but it was.
She said they had a verbal argument.
Yes. She said they had a verbal argument. The officer tried to move her down the street away from, and he felt she still wouldn't talk to them about what had occurred. She continued to say that no assault occurred. And she was, But I still think in part, I would say her nervousness was that she was surprised. She did not expect the police to be there. So that accounts for some of her nervousness. But I still think that it's a stretch to draw an inference of an assault from somebody. If we took this out of the domestic violence context, and I think these cases are hard, and I don't think I would be here. I think this case would have been, I don't think there would have been a finding of violation. I think and again, I'll turn to my argument about the bad act evidence improperly coming in. But I do think we have to be aware of our own institutional knowledge of domestic violence and what we bring to, and how we might be inclined to fill in gaps in the evidence. Because conceptually, this is double hearsay from a declarant with no personal knowledge. And it's like a fuse, a blown fuse in the chain. That doesn't work properly. But, it's like, here's,
All right, well,
right?
I think we'll have to leave it there, but I think we get your argument.
Oh, thank you. And I'll rely on my brief for the rest.
Thank you, Counselor. And we'll hear from the Commonwealth now, your second argument today, I understand.
Yes, Your Honor.
Whenever you're ready.
Thank you, Your Honor. Good morning. May it please the Court. Stacey Gauthier for the Commonwealth. It's the Commonwealth's position that the judge did not make any error in revoking the defendant's probation based on hearsay within hearsay statements. And we know here is a probation surrender hearing, so the standard here was preponderance of the evidence. And we know that reliable hearsay can be the basis of a revocation proceeding, provided that it's substantially reliable. And I would suggest that in this case, the statements were presumptively reliable and substantially reliable. So we have the first statement, the call from Ms. Levesque to Ms. Olf. I would suggest, and the judge found, that was an excited utterance. And because that's an excited utterance and falls within the hearsay exception, that is presumptively reliable. An excited utterance, under the right circumstances, would certainly be allowed in at a trial at a higher burden of proof. And the judge here found that Ms. Levesque was still under the stress of the events, and she found that the statements were made in circumstances where Ms. Levesque would not expect them to be used in court because she had made them to her friend.
But Officer Chase didn't testify what time he got there or how much time elapsed since the 911 call. So how do we know the timing?
So my memory is that Ms. Olf had told the operator that she called the police about a minute after speaking to Ms. Levesque. Excuse me. And I believe that was around 8 o'clock. And then I believe that the officer testified that it was between 8:30 and 8:40 that he was dispatched. And then when they arrived, she was still in her truck outside and still seemed to be upset. And if you'll, I can just look in my facts. So Ms. Olf stated that Ms. Levesque had just hung up the phone maybe about a minute ago, and that's at the record appendix on page 49. And then the officer, I believe I don't know if it was in my, sorry.
Okay. Oh, yeah, you're right, at page
Okay.
40. We responded at, I want to say, like 8:30, 8:40.
Thank you. So she was still under the stress of event. It was a short amount of time, and I believe the judge in her findings also made the finding that it was within a short amount of time. And Olf, although she didn't have personal knowledge of the incident because she wasn't there, she did have personal knowledge of the phone call from Ms. Levesque to her. So she was a precipient witness of the excited utterance. So I would suggest there's no issue with the excited utterance, and that it was presumptively reliable because it falls within a hearsay exception. So then we have the statements that Ms. Olf made to the dispatcher, and those, they do not fall within any hearsay exception and would have been able to be admitted at a trial. However, at a probation revocation proceeding, if the judge finds that they were substantially reliable, they can be the basis of a revocation. And so the judge made those findings and found that because the statements were corroborated by other evidence and other testimony, they were substantially reliable. And so the judge's findings were that, Ms. Olf said that the victim was in a cranberry-colored truck. The police arrived there. She is, in fact, in a cranberry-colored truck. She appeared to be upset and crying. The judge also found corroboration of the assault and battery because she had, according to Ms. Olf, Ms. Levesque told her that the defendant choked her and messed up her face.
What do you say to defense counsel's argument that Ms. Olf is not a disinterested witness?
She's disinterested in the sense that she doesn't know the defendant, so she has no axe to grind, no reason to get him in trouble. And with regard to her friend, the fact that she calls the police, that the friend is telling her, don't call the police, and she calls the police anyways, that I would suggest shows that, the friend doesn't have a motive that she's trying to use Ms. Olf to get her boyfriend in trouble. It appears that the only reason why she called the police was to just get her friend help. And we know that because, she's not friends with the victim anymore. So she called against her own interest in being friends with the victim. And so the judge had made the findings that the assault and battery was corroborated by where Ms. Levesque had told Ms. Olf that the defendant choked her and messed up her face, and the police get there and she's got redness around her neck. She's got bruising on her lips, and she's got blood in the corner of her mouth. That corroborates, what the assault and battery. The police then go to the address that Ms. Olf had given them as being Ms. Levesque's address. They get there. The defendant's the only person there. His name is Matt, as Ms. Olf told the police. It appeared that the apartment, there had been a fight. The furniture was all messed up, and there was still food burning on the stove. And then the victim herself corroborated that the caller on the call to the police was, in fact, her friend, Ms. Olf. And then Ms. Olf reported her personal information to the police, so she was identifiable. So I would suggest that shows that those statements were substantially reliable. And if there's no further questions for the other issue, I'll rest on my brief.
Wonderful.
Thank you.
Thank you very much, Counsel, both of you. Interesting case, and we've been definitely helped by your presentation.
Thank you.
And thank you for moving to transmit that exhibit, or bringing the exhibit, rather.
Yeah, well, we will locate it, unless you guys already have it.
I don't.
Yeah, we'll find it, and we will listen to it. All right, let's keep pressing on. I'll call the fourth case, 22P 358, AD versus MD. This is being live streamed on the internet, so we'll have to be careful not to use the actual names of the parties. We can call them husband and wife or plaintiff and defendant, and please do not name the children. You can use initials if you need to mention them, or just call them the children.
Of course. May it please the court, Dana Curhan for the husband. We contend that the trial court erred in two extensions of a 209A order. Before I begin my presentation, I think there's a procedural issue that was raised in the wife's brief. Specifically, they contend that because the orders were docketed in April of 2022, we needed to file a new notice of appeal. What happened was the two orders were docketed on the day they were issued, and we filed timely notices of appeal. In March of 2022, after trying to get the record assembled on the first hearing that we challenged for a year and a half, and on the second one for a year, I filed a motion to compel assembly of the record. At that point, the court called me and said, we can't find the file, or we can't find most of what's in the file. Can you send us copies of the orders? Which I did. And apparently they redocketed everything, and I didn't realize that I had any kind of obligation to file a new notice of appeal. The court assembled the record within a couple of weeks after that. So that's where we are. It's our contention that
You say they were docketed, and then they were redocketed?
they may have been redocketed when I sent the copies. It was the copies that were docketed. But as to the original, if you look in the docket, on the day that each of the orders was issued, they were docketed on that date, and the notices of appeal were timely.
We'd say we appreciate always when attorneys assist the clerk in assembling the record. The rule says to, but not everyone does.
Yeah, I mean, my intention was to have this case up here a year ago. Right now, the orders were, after the second order, it was not extended. But, so we're here arguing orders that have since expired, and I think that wasn't our intention. But I think nevertheless, we have arguments that would benefit us to have these orders not continue. And by the way, I forgot to introduce my co-counsel, Corey Madeira, who was trial counsel in this matter.
Welcome. Always good to have trial counsel.
And here's the first problem with the August 2020 hearing. The judge said, essentially it was taken on representations of counsel. And then...
But it was representations of counsel about what happened at the May 2020 hearing that was also before Judge Cronin.
Yes. Counsel asked to cross-examine the complainant, and the judge said, no, this is not an evidentiary hearing. And then they argued the case. That's sort of the first problem. So we contend that there should have been an evidentiary hearing.
Normally, what we do in that situation is remand for an evidentiary hearing, but one was held in February.
Yes, one was held in February. Now, as to both of these hearings, our issue is that we contend that there was no evidence that would support an ongoing need for a restraining order. I mean, here's the problem. Sometimes you have somebody who goes in and there's a history of domestic abuse and ongoing things, and I understand that. Those things, I think substantial deference should be given to any kind of expression of fear. But there's a second category of cases where, leading up to a divorce, one of the parties goes in and gets an order, and I suggest for leverage in the divorce proceedings, in circumstances where, maybe it's not necessary. Yes, there is high conflict, but once the parties are separated, what is the ongoing need for this order?
Well, in thinking about that, shouldn't we defer to the discretion of the probate judges who, especially given the fact that they modified the order to permit exchange of the children and, in fact, even the dog? So doesn't that show that the probate judges were aware of the problem you're discussing, that in the heat of the moment, parties may seek an order that is more than what's later needed?
I think that's one way to look at it. I mean, and the fact that the judge did issue or did accept these stipulations and enter these orders does actually support my point that is there a real need for a restraining order here? You know, I mean, but to further support my point, at the first hearing, you know, one of the representations was that the wife, in anticipation of a divorce, did some safety planning. And she had the guns removed from the house so that when she sprung, you know, the divorce on him, that there wouldn't be guns. And, you know, I would suggest that, you know, the second incident, the incident in the shower, was something that was really planned in advance. And regardless, I mean, we have to accept it because we didn't challenge the May 2020 order. But at each hearing, I think that I suggest that, and the case law suggests, that there needs to be a showing of ongoing need for the order. And we just don't have that here. You know, at the August 2020 hearing, part of the representation was, you know, his behavior is controlling. He texted 15 times regarding the sprinkler. They were having trouble agreeing on a real estate broker. That's unpleasantness, but it's sort of necessary unpleasantness in the context of a divorce.
Well, there was one time that we almost had to stop the session because of how he was acting and how aggressive he was getting with his demeanor. Why isn't that the kind of thing that would require a continued need, suggest a continued need?
I mean, without some explanation about what that was, if he's aggressive in saying, you know, I want the I think, you know, the sprinkler ought to be pulled up or serviced or whatever. I mean, I don't know. We don't have any detail of what that was because, again, at the first hearing, we weren't allowed to cross-examine on that. And at the second hearing, I think the wife's, I mean, I would suggest if you look at the second hearing, the wife really sort of backed down on some of the incidents that she had alleged originally. So, you know, again, we just don't have, in this case, we don't have anything supporting an ongoing need for a 209A. And again, especially in view of the order saying, yes, the children can go with the father unsupervised, and he can do pickups and drop-offs and all that other stuff. And he can have contact with the wife, and she can join him for dinner on Wednesdays, and they can attend family events together. I just don't see it. And the final point I want to make is that this order also extended to the party's children. And there was nothing in the affidavit.
What I don't get is that happened originally, was extended in May in the order you don't appeal. And then everything about the children that happened after that, in April and in February, was by stipulation. So what are you appealing? I mean, you stipulated to the reduction in the restrictions as to the children. So what is there to appeal?
Well, the order was never vacated as the children. There were some limited concessions and stipulations as to what will happen with the children or what kind of contact is allowed. But I know that the order is not in place, but the order did create the risk that there could be some kind of contact.
Right, but you didn't appeal the order that said stay away from the children. The only thing that happened in the two hearings was a reduction, an allowance of certain amounts of contact with the children. So what is there to appeal?
Well, I know that at the February 2021 hearing, there was the issue of the children was addressed, and counsel argued that there's nothing supporting extending the order as to the children. In February 2021, that order was extended, and the order included the children. And there had never, even in the initial affidavit, there was nothing addressing the children.
So you're saying even though there was a stipulation as to the children at some point, at some later point, there was no continuing need for that.
That's right, and I don't think the stipulation was necessarily, we agree that there should be an order against the children, but here's the exception.
No, I get that. So your suggestion is that the error is in not modifying the order to eliminate all restrictions on the children.
That's right.
Okay, now I get it.
And that was actually addressed in, I believe, at the February 2021 hearing. I don't know if there was, I don't think it was specifically addressed. There was an argument that the whole thing in August 2020 should be vacated. But at the very least, in February, that argument was made. Unless there are any further questions, I will leave the remaining points of the briefs.
So, but you do agree that we're looking at the judge's discretion. That's what we're reviewing as to your issues.
We're looking at the judge's discretion, but I think we also have to look at whether there was evidence supporting the extension of an order. And if there's no support for it, then I think the judge's discretion is very limited.
All right.
Thank you.
Thank you very much, Counselor. Whenever you're ready.
Good morning, Your Honors. Lynette Petchkuski representing AD. And may it please the Court, I'll touch on the first issue very briefly. The docket report from the probate court is in the record appendix, and if we look at record appendix 5, the orders do not appear to be docketed on the docket report. So I accept my brother counsel's representations as to what happened on his end, but from a procedural standpoint, when we look at the
I don't know about that. I'm looking at 5, and it says 2/22/2021 has been, order issued.
Your Honor, I would contrast that with, for example, the 5/20 and 5/27/2020 docket entries, which actually identify order entered, the date that it entered, the terms on which it is, when it is extended until. That is the docketing of an order, as opposed to the 8/27/2020 and 2/22/21 docket entries that are a description of the event that happened in the court that day, not the docketing of an actual order.
But why isn't order issued enough to allow you to appeal? Yeah, it'd be better if it said what the order was and when it expires, but why can't you appeal something until the docket explains everything about it, as long as it dockets the order?
Your Honor, I would submit that the event resulted is not the actual docketing of the order, and it may be splitting hairs in a matter of semantics, but there are any number of times in the trial court where there's something that happens and we see, matter taken under advisement, order to issue, order issued, but because there's a whole process that happens behind the scenes of a judge writing the order, a secretary typing the order, it getting docketed, there's often a delay between when an event happens and when the order gets actually docketed. And I just would submit that with respect to this docket, it does not actually reflect the docket or the order entering until 4/4/22. You see the actual difference between the event resulted and when it says order entered, and that's the docketing of the order. If you went to the event resulted on the docket, I suspect that you wouldn't be able to actually pull up an order because there's no order attached to it. But moving on to the actual substance of the arguments, it is our position that the extension should be affirmed and that costs and fees should be awarded.
Can you have an extension hearing without evidence by witnesses?
I believe you can, Your Honor. With one exception, the first extension hearing, so if an ex parte temporary order issues and it's not a full two-party hearing, and that I think that by all accounts, due process provides that the respondent be given an opportunity to be heard. And I think you do need to have a hearing, give people an opportunity to be heard, take the evidence, and make the necessary findings to issue the order in the first place. But then once that initial order enters and we're back at an extension hearing, at that point in time, the standard becomes a little bit different, and we don't have to relitigate and re-argue and reestablish the facts that led to the order in the first instance. What has to happen is the judge has to decide whether, in light of the circumstances present, an extension is reasonably necessary.
But the question is, can the judge determine what are the present circumstances without actual testimony or evidence being submitted? Can that be done simply on representations of counsel?
I think that it would depend on the circumstances, Your Honor. And you notice that there are two very different circumstances here. The August 2020 hearing, which was heard by the same judge who heard the May 2020 evidentiary hearing, it's a matter of 3 months. It's a matter of the same judge. I think that's a different scenario than the February 2021 hearing where you had a different judge who hadn't heard the evidence before. A longer period of time had passed since the last hearing. I think it put the judge in a different circumstance, and in her discretion at that point in time, she felt the need for an evidentiary hearing.
No, but I'm not sure why that matters, because at the extension hearing, as you mentioned, you're not going back and relitigating what was done the first time. You're talking about present circumstances. And how can the judge know the present circumstances? Well, you can know it through representations of counsel, but why is that sufficient at this point, rather than new testimony concerning the present circumstances?
I would point to two things, Your Honor. And first is, I think it's very important that in this case, we're not dealing with a district court restraining order in the context of a probate court divorce. We are actually in the probate and family court. And second for that, if you look at the INL case that is cited in our brief, when it talks about the facts that could justify an extension or a continuance of the restraining order, it talks about the totality of the circumstances. It talks about, and some of the examples of what may lead to the judge's consideration are any violations of the existing order, whether there's ongoing litigation and opportunities for contentiousness and hostility, and whether there's opportunities to encounter one another. Certainly with respect to those last two things that I mentioned, the judge sitting in the probate court knows, without taking evidence per se, what the status of the divorce proceedings.
Nothing happened between May and August that I see. Were there hearings and divorce that I'm not seeing?
I believe the divorce was just proceeding and then the normal course, whether parties were doing discovery or whatnot.
So if in May, Judge Cronin thinks he's got enough to extend it for 3 months, then how can he extend it again in 3 months without finding out how the circumstances have done? If the circumstances are so clear in May that it had to go for another 6 months, wouldn't he have extended it for 6 months?
Your Honor, if you look at, so the May transcript was not provided in the record appendix, but there was a representation by the judge that the intent was to track the restraining order with the divorce proceedings. And so if you look at the transcript of the August proceeding, I believe the parties were there for a pretrial conference. And so there was, I believe, some effort by the court to not necessarily overreach and overplan for how long this restraining order was going to be a necessity. It was, okay, well, let's evaluate at the pretrial conference, because as sometimes happens in a divorce case at a pretrial conference, the parties actually get divorced because they've reached a separation agreement. And so I think the intent from the court, based on the transcript, and I know Your Honors don't have that in front of you.
So let me ask you about that. I understand that it's the other party's burden to present what's necessary for us to review this appeal. But is it appropriate for you to be making representations of something that's not before us? You're telling us this is what's in the recording, although the transcript isn't before us, neither is the recording.
I understand the difficulty in that position, Your Honor.
So the other issue is, you pointed out that this is not a district court restraining order. The district court restraining order and the probate and family court restraining order, are they the same restraining order? Are they governed by the same rules?
They're governed by the same statute, but I bring that up, especially particularly in light of my counsel's point that he made during his presentation of people sometimes use these proceedings to get a leg up in the divorce proceeding. In my experience, when people are doing it for that purpose, they do a little bit of form shopping and go to the district court. Here, this is in the probate court. They're in the context of the divorce. And to the point with respect to the children and whether this was a leg up or not, I point out to Your Honors that under the statute, temporary custody of the children is an available means of recourse to protect the victim from the abuser. And so that happened on a temporary basis, and at the very first extension hearing, the very first evidentiary hearing, the very first two-party hearing, pursuant to the authority under the statute, that restraining order was modified so that dad had ability to contact the kids, but it sets the parameters around that in order to protect mom, the victim of the abuse, so that the other party can't use the kids as the leverage and the advantage to continue the abuse of the mom. So those parameters are very important, and they were entered as temporary orders in the divorce proceeding, and that serves to modify the terms of the restraining order to set the parameters pursuant to which the contact can occur for the children.
I believe you mentioned in your brief that it's common practice in the probate and family court to, I think typically if you're entitled to a restraining order, you're entitled to a one-year restraining order, but that it's typical in the probate and family court to simply extend it hearing to hearing. And you indicated that it would somehow be unfortunate if the probate and family court didn't have an opportunity to continue to do this. Don't our cases say that actually say that the courts shouldn't give the restraining orders for a 1 month period, a 2 month period, a 3 month period? If you're entitled to it, you should have it for the 1 year, not have to revisit it at every court appearance.
I think that becomes a matter of discretion for the court in terms of what that judge who is hearing the extension hearing feels is appropriate, again, taking into the totality of the circumstances of the case. We unfortunately can't go back into the judge's head to find out what they were thinking, but again, coming back to the totality of the circumstances that a case like INL suggests the judge should be considering, we have to look at the opportunities for them to encounter one another, the ongoing litigation, the status of that. And so, when you're in the probate and family court, that judge may have a sense of how contentious or uncontentious litigation is and whether there's moments for ongoing hostility. The judge can see what's happening with respect to parenting exchanges and with respect to all the stipulations that were entered into to modify the restraining order to give dad contact with the children. And so that judge may have seen, that at some point there wasn't going to be an ongoing need for this and may have tracked it in accordance with the divorce. We don't know, but I think that it's a different circumstance when you have a judge who's actually sitting with the divorce and actually knows what's going on.
So when you have an extension hearing in front of a judge who had not previously heard the matter, are you saying at that point an evidentiary hearing is required?
Again, I think it's in the judge's discretion, but I think that in this circumstance, Judge Moses made the determination that an evidentiary hearing would be appropriate. For whatever reason she made that determination, she felt that she wanted to take that evidence. It may be because she hadn't heard the case before. It may be because a longer period of time had passed. It may be because there were, ongoing stipulations for the children. But you would
still say that it was appropriate it would have been appropriate if Judge Moses had not taken any evidence?
I think it's a matter for her discretion at that point in terms of whether she needed new evidence to assess what the current circumstances were. How
do you assess what the circumstances are without evidence?
I'm sorry?
How do you assess what the current circumstances are without evidence?
Well, again, I think with respect to the status of whether there's any ongoing litigation, whether there's any ongoing opportunities for hostility. Again, the judge in the probate court knows what the status of the divorce proceedings are. With respect to whether there are opportunities for these parties to continue to encounter one another in their day-to-day existence, that judge knows what the temporary orders are and knows when they're encountering each other with respect to parenting time exchanges and the like. And again, I think
if
that
you prevent the parties from presenting evidence, then the judge is sort of shutting themselves off from maybe relevant evidence regarding the present circumstances.
But I also don't think there was really any disagreement between the parties as to what the status of the divorce proceedings was, or with respect to how often they encounter one another. The dispute between the parties is really this allegation. And again, I believe, as we say in our brief, we think it's the inappropriate standard to be focused on. There seemed to be a focus on whether or not there was an imminent fear of serious physical harm. And I want to touch on that very briefly because that shouldn't be the focus for what the current circumstances are. The three prongs of what can constitute abuse, there wasn't a reliance on the Section B standard of a fear of imminent physical harm. Although that was partly pled, what was focused on was the actual physical and sexual abuse that had happened. And so where that abuse has already been established, that's also another reason why there may not have been a need for the evidentiary hearing, because we're not talking about what the current circumstances are in terms of the reasonableness of an objective fear of imminent physical harm.
You're still assessing whether the person continues to suffer from that abuse, whether that's sort of a reasonable finding. Right? And so wouldn't somebody be entitled to present evidence that would bear on that issue? And so when a party says, Judge, I don't think this extension, I don't think this order needs to be extended any further, and let me put on some evidence to convince you of that. They don't have that opportunity to do that?
I think that with the judge's discretion, if he, it's particular with August, because again, in February, there was an evidentiary hearing. So I'm assuming your question is limited to the August hearing where Judge Cronin declined to make it an evidentiary hearing. If he felt that he didn't need to, based on the evidentiary hearing that had occurred previously, based on what he knew of the attendant circumstances of the case, and based on any representations of counsel that weren't really in dispute, I think he could have made that determination.
Let me ask you about your request for attorney's fees. Is it just based on a claim of frivolous appeal?
I'd point your honor to the ROCHA case. In that case, because of the fact that the appellant had argued, it's very similar. The appellant had argued, at least in part, that the complainant had to relitigate and reestablish facts. And in the ROCHA case, the appeals court said the law is clear that the complainant did not have to reestablish those facts, and where that formed at least a portion of the basis for the appeal, the attorney's fees and costs were awarded.
But does that mean it's because of that? That's why you want attorney's fees?
Yes, Your Honor.
Okay. All right. Thank you. Thank you both. Very well argued. We will take a break at this point. It's going to be brief. I know you don't believe me, but it really will be.
All rise, please. please be seated. Good morning, everyone.
All right, we're back in session. I'll call the fifth case, 22P557, trustees of the 219 to 229 Bowden Street Condominium Trust versus AY Enterprises, LLC. All right, Counselor, whenever you're ready.
Happy New Year.
Good morning. I'm Julie Berry here for the appellant AY Enterprises, and with me is my colleague Nicole Kokoza.
Welcome.
Thank you. So the essence of our brief and our argument, as the court is surely aware, is that our contention is that the trial court erred in granting summary judgment in favor of the Cardoso Trust, excuse me, finding an easement or a general easement to use what is labeled Lot B on a 1960 plan that I think is illustrative for the court, and the best copy of that plan, if I could let you know, is actually in the appellee's supplemental appendix. It's a clearer, larger version. Our attempts to shrink it down made it, so it's at SRA 0022. And that plan depicts the lots that are discussed repeatedly throughout both the parties' briefs. So in this case, as your honors are aware, this is an easement case concerning the use of what's depicted as Lot B in that 1916 plan. The issues that we are arguing that the court failed to consider concerning its issuance of summary judgment in favor of the plaintiffs and the denial of AY's motion, cross motion for summary judgment, are several. In the first case, it's beyond dispute. It's the plaintiff's it's the plaintiff's burden to show that there is an easement, and easements are established through evidence that show the nature, the purpose, the intent, the scope, providing evidence that shows the dominant and servient estates, the recorded aspects of the easement, where it can be found. It's to provide guidance to parties looking for information going forward. And
Counsel, do you have any case law about what the word over means in a deed describing a right-of-way?
I don't think we actually have case law regarding that. What we did was rely on the definition of over, which is cited in a footnote of the black law definition of over, or which is cited in our brief, but I don't think that we have any case law. The court surely knows it's our position that at the time this easement was created, and there's no circumstances or evidence showing how it was created, but at the time it was created, as referenced in a partial release from the Dorchester Trust to Mr. James Sullivan back in, I think, 1920. At the time of the release, there was no other information given as to the purpose, but Mr. Sullivan owned lots A and lot C in common, which are divided or lying between lot A and lot C as lot B, or parcel B as it's described. It is not described on that plan as a right-of-way. The only time the word right-of-way appears is in the partial release, and the facts before the judge do not show that there was...
And the deed.
Sorry?
And the deed.
And the deed, which puts that language in there about a right-of-way, but there's no other evidence to support that. other than, I mean, our argument from as to the intent, in which case, if there's a question of intent, this court knows that this is not ripe for summary judgment. Intent is always a core issue in easements when there's any ambiguity or not clarity as to what that easement, the confines, boundaries, nature, purpose, intent of that easement, which is clearly what happened here.
So are you saying that the language in the deed is ambiguous?
I am saying that the language is in the deed is ambiguous when you consider the circumstances surrounding that creation. And it's not only ambiguous, but it doesn't provide going forward what happens in the event of disparate ownership of these parcels. At the time that was created, Mr. Sullivan, having paid off his mortgage for lots A and C, received title from Dorchester Trust for those lots.
So are you saying that when Mr. Sullivan owned this, he really could only use the right-of-way on Lot B to get from Lot C through to A? He couldn't use the right-of-way to get to Bowdoin Street?
There's no curb cut to Bowdoin Street. There's no evidence. There was no evidence before the trial court that Lot B was used for ingress or egress to Bowdoin Street. There's no reason for it. These properties front on Bowdoin Street. The only thing that Lot B leads to is Lot D, which is under separate ownership.
In December 2016, who owns Lot B?
December 2016.
Or let's say January 2017, the day after this stuff happens. Who owns Lot B?
Lot B is owned by the bank still in terms of its conveyance, the conveyance by Mr. Sullivan to the bank that went along with the mortgage, and the language is very clear in his giving the mortgage that he was conveying those lots to the bank.
The bank holds title and Sullivan has the equitable and possessory right. So if he has a possessory right, he can go on Lot B all he wants, easement or no easement, right?
I don't know that that's entirely correct, and I think that the issue is that because the bank held paramount title, this was a way of avoiding any issues concerning that. The question, though, and again, this is where summary judgment is wholly inappropriate for this case.
I assume you've had a mortgage at some point in your life. I assume you stayed in your house. The bank didn't make you leave as a trespasser.
Correct.
So he had every right to do B even before to go on B even before the easement, right?
But the question, I think, is that what was going to happen to these lots in the future. And again, because there's no discussion of the creation of this easement, and because the Lot B does not lead to anywhere, it's not an ingress to Bowdoin Street. There's no evidence about that. It leads to Lot D. That's where it goes. And Lot D is not owned by the trustees. The AY Enterprises owns Lot B, C, and D. The trustees only own Lot A. They have no reason to access Lot D. It's not their property.
It seems like you're suggesting there was no purpose for the easement ever.
I think it might have been a belt and suspenders issue, honestly, Your Honor, and that's the problem with what we have before us in the record and the trial court's failure to examine this. And this goes right back to the other issues in our complaint. I mean, I know that we have an issue, and I'm going to rely on our papers for the attorney's fees question, but this summary judgment motion was brought and is set forth in our brief without any evidence to support an easement.
Don't rely on your papers, because I've never seen an appellant request double attorney's fees from an appellate court before. So I would like to know what the basis is for that.
The appellee, you mean?
You're the appellant, and you're requesting double appellate fees, attorney's fees. And I've never heard of any such thing. So I'd like to know what the justification is for an appellant to ask for double attorney's fees.
I understand your question. I'm sorry, I was confused for a minute. Because the reason that we're here, Your Honor, is that this is an appeal of a summary judgment decision that the trustees did not put the evidence on that they needed to in order to get this. Their first iteration relied solely on the complaint and a few deeds attached to it. They didn't provide any deeds to the court concerning evidence of this easement until after AY filed its opposition and its cross motion for summary judgment. Even then, they didn't file all the deeds that they needed, and it wasn't until almost the day before the hearing that the trial court actually reached out and asked the trustees to provide copies of deeds to fill in all the gaps that were left in the record. This is extraordinarily frustrating, time-consuming, and costly waste of time for all the parties. The person seeking to prove an easement has the obligation to produce evidence to show that they're entitled to an easement. That evidence usually consists of things that show the purpose of the easement, the circumstances surrounding its creation, and otherwise trying to ascertain the intent of the grantor of the easement. None of that is provided here. There's no acknowledgement that after the property, lots A and C diverged in ownership back with the McPherson deed, that there was ever any common ownership again. Once Lot A was divorced from these other lots, there was, and again, because there's no evidence of any curb cut or other egress onto Bowdoin Street as being the purpose of this easement, there just isn't, there wasn't any evidence before the trial court.
But if the easement is in the deed, does it make a difference what the purpose was? So if Mr. Sullivan had a stable of horses that he needed to access the right-of-way to get his horses out to Bowdoin Street, and nobody on Bowdoin Street has horses anymore, but that easement's in the deed, what difference does it make if the original purpose is frustrated?
The difference is that without understanding the purpose and the intent of the easement, and without acknowledging or understanding that the scope of the ownership and scope of easement may have changed over time, what you are faced with here is an easement that provides unfettered, unrestricted access to Lot A, interfering completely with the owner of Lot D's rights to access Lot D. There is no other access or egress to Lot D except via Lot B.
I don't get that. It's a right-of-way. All you can do is pass over it. How does that stop the owner of D, which is you?
Which is the point of our, first of all, if looking at the 1960 plan, there isn't any purpose to pass over Lot B for Lot A. They don't own Lot D. They're not, where are they passing to?
Bowdoin Street.
But there's no curb cut or evidence that that lot is to provide ingress on Bowdoin Street. That was an error on the trial court's part. There is no evidence whatsoever that Lot B.
In 1916, why would you need a curb cut? People probably didn't have cars in 1916.
That could very well be the case. But again, none of these things were examined by the trial court, which is why we're here today. There's no purpose. Lot A fronts on Bowdoin Street. You don't need access to Bowdoin Street from Lot B for Lot A, but you do need access over, unfettered access over Lot B to Lot D. And
Why can't they both have access over Lot B? Both Lots A and...
Because there are conflicting, because there wasn't an examination of the purpose, the intent, or the creation of this easement, there is a direct and continuing dispute over what it means for passage over that right-of-way, such that since the trial court's decision, which can be gleaned from the docket which we presented to the court, there has already been wrangling over the trustees' use of the lot for more than just passage, parking it, blocking it, using it in ways that are inconsistent.
I don't understand. I mean, that's obviously inconsistent with this easement. This isn't an easement to park there or to block it. It's a right-of-way. If they're doing that, like the trial judge said, you should sue them or tow them.
Well,
you could tow them.
But this lawsuit was already brought, and the role of the trial court was to ascertain the easement, how it was created, whether it was created, the purpose for which it was created, in order to put the rights of the parties in order. That's why the lawsuit was brought to begin with. Instead, what we have is a decision on summary judgment not supported by undisputed material facts. There are certainly, intent is always a question of fact. And
sounds like you don't think you're entitled to judgment either.
I think that what we requested was a remand to the court for further investigation determinations as to the facts and circumstances concerning the creation of this easement, because all it's led to now is the inability of the owner of Lot B, C, and D to, at times, not be able to access
Hold
Lot
on.
D.
So your brief ends with 5 requests. The second one is to allow your cross motion for summary judgment. So I want to know which of these requests you still want, if you don't want that one anymore.
Hang on a second. I'm sorry, I didn't mean to use the vernacular, I apologize.
You can be vernacular, that's fine.
I didn't mean to tell you to hang on. Let me get,
I'm happy to hang on.
thank you.
Pages 54 and 55 of your brief.
But we do need to know exactly what you want us to give you.
So what we would like you to do is remand to find that AY is entitled to the court having allowed its motion for cross-summary judgment, or essentially it's cross-motion finding there should not be summary judgment because there are material facts in dispute. And so the request is in C to remand the matter to the trial court to proceed to trial to determine the scope and the intent of the easement so that we don't have this conflict of movement over a right-of-way that essentially, for purposes of Lot A owner's use, goes to nowhere because they have no rights to access Lot D. And just briefly, the attorney's fee issue that has been raised by the appellees. We have addressed this in our reply, and I know that they sought to file a surreply.
All right, well, your time is up, so we'll have to leave it at that, but everything in your brief is preserved.
Thank you, Your Honor.
Thank you, counsel. All right, counsel, we'll hear from you whenever you're ready.
Good morning, Your Honors. My name is Matthew Dunn. I represent the plaintiff and appellee, the trustees of the 419 to 429 Bowdoin Street Condo Trust. My client's representatives are in the gallery here today. I'd ask this court to uphold Judge Roberts' decision on our motion for summary judgment. This is really the fourth bite at the apple for AY in challenging that decision. The first was through the motion for summary judgment. That motion was supported by the chains of title for all the properties that are involved in this. As my sister indicated, what you have here is an original lot that was subdivided by Mr. Sullivan back in 1916 into 4 lots, A, B, C, and D. The condo trust owns Lot A. The AY owns lots C, B, and D at this point, but originally, and I think that this is important for the court, this is an express grant of a general easement that was created back in 1916 by Mr. Sullivan when he conveyed the properties out originally to Miss McPherson. That was lots A and C. The easement indicated that it ran from Bowdoin Street to the rear of Lot D. So it was pretty express with regards to the dimensions and width of the easement. And it's our argument that the purpose of that was so that you could go from the front on Bowdoin Street of Lot A and Lot C to the rear of those properties because it's kind of an oddly shaped parcel. And that's in fact how the owners of those lots had used that particular easement. It's important to note as well that after Ms. McPherson was deeded A and C, the titles to those properties diverged to different individuals. And in each chain of title after Ms. McPherson, for Lot A, again, to a different person, and Lot C to a different person.
Do we know what happened to Lot D? I mean, I know what happened to Lot B, but do we know what happened to Lot D? I know it eventually ends up at AY Enterprises, but I wasn't following what happened in the meantime.
Offhand, I don't know what happened to Lot D. Originally, Lot D and Lot B were retained by Sullivan, subject to a mortgage in favor of Dorchester Trust, which doesn't affect Mr. Sullivan's ability to convey easement rights. That's really a junior, essentially a junior lien, and Judge Roberts talks about that in both her decision on the motion for summary judgment, I believe in more detail in her decision on the motion for reconsideration. So it's a junior lien, and it's an express grant, and there is a purpose to it. And to the extent that there is any ambiguity with regards to that purpose, I believe Judge Roberts was within her authority to make that determination. And I think that the case law in support of that is set forth in her decision on the motion for reconsideration. So you have an express easement. You have, in both titles, it changed the titles for both A and C. And Judge Roberts made her decision based on the publicly available documents that are on file with the Registry of Deeds that were presented to her as part of the summary judgment record. Now, perhaps that was a bit disjointed, but the sites to the book and page were always provided. As a matter of my understanding of Massachusetts evidence, the judge can take judicial notice of that. She chose not to. She asked for those actual physical documents to be produced. That was prior to the hearing on summary judgment. My sister and her client had a full opportunity to, A, oppose that request, and they did not, and were given additional time to respond to the actual documents and before hearing was ever heard. So there was no prejudice in the fact that the actual physical documents were not produced originally with the motion for summary judgment, because they were produced prior to the termination. They weren't opposed by my sister, and they do comprise what Judge Roberts based her decision on. And those documents require an interpretation of law. It's almost like it's a legal interpretation rather than a factual interpretation. And I think Judge Roberts provides the authority for her ability to do that in the motion for reconsideration.
Let me ask you something. The judgment seems a little oddly worded to me, in that it just says Lot B is subject to an easement appurtenant to Lot A for all reasonable uses to which Lot A may be devoted, but doesn't say right of way anywhere in there. I would have thought it would have said subject to an easement appurtenant as a right of way. Do you read this judgment as giving you anything other than a right of way?
No. I think it's an easement to pass and repass over Lot B in order to access the rear of Lot A, which has traditionally been used, and it was unopposed by anybody for almost 100 years. And it's been identified in the chains of titles for both properties. I understand my sister's argument. If that were the intent, meaning if it was to terminate after Ms. McPherson, after the unity of title diverged, there would have been something in the documents in the chain of title to reflect that. And there isn't. There's no limiting language anywhere in the chain of title that talks about, well, as soon as the unity of title diverges, this terminates. In fact, just the opposite is the case. You have express references from 1916 to the latest deeds out to AY and to my client that specifically reference this easement. And to the extent that the easement is not specifically identified, there is sufficient reference in each of the deeds to put everybody on notice that this easement exists. And that's sufficient under MGL 183, Section 15. So the easement is express, it's general. The law, Massachusetts law, gives Judge Roberts the authority to do exactly what she did, which is to interpret the documents, make the recorded documents.
And again, I hate to keep stressing this. When you say general, you mean, but you accept it's just a right of way.
Right. It's a general right of way to pass and repass. It's not restricted by, and it goes from Bowdoin Street to the rear of the property, and not, as my sister would argue, basically to be able to go from Lot A to Lot C. It goes from front to back, and I think that Judge Roberts was within her authority to make that determination. So to the extent that my sister disagrees with basically the use or the breadth of the easement rights, again, this was something that we've already talked about, not before this court, but before Judge Roberts on 3 separate occasions at this point. They have rights to challenge that, right? That's basically a separate cause of action with regards to overburdening or overuse or misuse of the existing easement. It doesn't really contest the very existence of that easement, which really should be uncontested. So if the court has any questions for me, I'm happy to respond. But with regards to any arguments that I may have missed, I endorse and incorporate Judge Roberts' findings in both her decision on the motion for summary judgment and her motion for reconsideration. And I'd also just direct the court to the brief that I submitted in support of our opposition.
I have a question about the language of the easement. As I see it, this basically said a right-of-way over Lot B. And I've seen, as you mentioned, there are often wording of easements in deeds that will say to pass and repass, and for all purposes typically used in this town or something like that. Was there a historical change in the language? Is there a reason to use one versus the other?
I haven't been able to find that, Your Honor, and I think that Judge Roberts in her motion for reconsideration indicates that that's pretty standard language. It doesn't necessarily create an ambiguity, as my sister would argue, with regards to what the scope of that easement is, and that there's I believe in the motion for reconsideration, the judge indicated that there was 622 references to a right-of-way that creates an easement to pass and repass over property, and that it's not uncommon to use that in creating an express easement.
Thank you.
Thank you, Your Honor.
All right. Well, thank you, counsel. Thank you both, and all three, counsel. This is very helpful to the court.
Thank you, Your Honors.
All right, I'll call the last case of the day, John Doe number 527548 versus the Sex Offender Registry Board. Did I say the case number? 21P1010. I'll remind the parties, though I know you two don't need any reminder, but this is impounded. We won't be using the offender's name. Normally I'd say we won't use the victim's name here, but there isn't one, so we don't have to worry about that. Whenever you're ready.
May it please the court? Excuse me, I have a little cough. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today requesting that this court either lower my client's classification level from a level 2 to a level 1 or remand the case back to the board for another classification hearing. I would assert that the hearing examiner misapplied 2 of the regulatory factors in his decision. First, the hearing examiner erroneously gave only minimal weight to risk mitigating factor 30 instead of significant weight. Factor 30 is in regards to advanced age. Here, my client was 60 years old at the time of the classification hearing. According to the plain language in this regulatory factor, the hearing examiner should have given my client significant risk mitigating weight since he was 60, which is the age that indicates in the factor that the offender should get significant mitigating weight.
But couldn't the hearing examiner infer that your client was an outlier? In other words, most 60-year-olds aren't at risk of committing sex offenses, but because your client committed this offense at 56, that inference is less plausible.
What I would assert that if you read the language within this regulation, you'll see that there's no wiggle room there in terms of applying the significant weight. There is wiggle room if after they reach that age of significant risk mitigating weight, then they could, if they continue to offend after that, then they could apply less weight to this. That would be my assertion in regards to this factor. Additionally, I'm so sorry.
Would you like to get some
Additionally,
water? Would you like to get some water?
Yes, please.
If you need an extra 30 seconds, we'll get it for you. I know once you start talking, it's a whole different ballgame.
Additionally, I would assert that the hearing examiner erred by applying only moderate weight instead of full weight to risk mitigating factor 34, which is stability in the community. As you'll see from the record appendix here, my client had a tremendous amount of stability in the community. He had a stable home to live in. He was living with a good friend of his in East Hampton. He had a stable income. He had a history of working as a carpenter, but he was unemployed during the hearing because of the coronavirus. So he was receiving an income, though. Additionally, he had the love and support of many family members, friends, and people from the community, including a pastor. He was very involved in his church. He had no issues with drugs or alcohol. So I would say that the hearing examiner should have given this factor full risk mitigating weight. Additionally, I would argue that there wasn't substantial evidence here. The board did not prove by clear and convincing evidence that my client poses a moderate risk of reoffending. As you know, my client has only committed one sex offense. It was committed in 2017, and in fact, this is the only conviction on his record at all. It was a no-contact sex offense. It was against one victim. Again, as I indicated, he has no issues with drugs or alcohol. He has a lot of support from family members and friends. He does take full responsibility for his actions, and I would contend that he is getting older, so the risk of him reoffending is actually decreasing throughout the years. He was 60 at the classification hearing. He's 62 today. He does have a supportive home environment, and again, he has a stable income and a stable home. So for these reasons, I would argue that my client's classification level should have been a 1. But if you choose to remand it, I would also welcome that. So if no further questions, I'll rest on my brief.
Thank you, Counselor.
Thank you so much.
If it pleases the court, David Chennai for the board. The pouring of the water reminded me a couple of years ago during an argument, I decided to pour myself a glass of water while I waited my turn to speak and missed the cup completely.
I've done that myself. Not when I was an advocate, not yet as a judge.
The board's position is that, the recency of this sex offense and the type of sex offense warranted the level 2. I can't see him being a level 1 less than 4 years after this incident. The hearing examiner looked at the mitigating factors and found that the mitigating factors did indeed reduce his risk and danger, but found that it was a moderate. I think that was a fair decision under the circumstances. Unless there's specific questions as to any of the issues raised, I'd be more than happy to rest on my brief.
My only question, and it's more a rhetorical one, is there a degree to which, in deciding if there should be internet dissemination, do hearing examiners consider whether or not there was internet involved in the underlying crime?
I don't think the hearing examiner did that in this case. I think a hearing examiner could consider that. I'm trying to remember what the hearing examiner's decision was on that issue in his discussion. I think he does mention in the reason for internet dissemination the fact that young individuals on the internet should be aware of him.
Thank you.
Just out of curiosity, do you always do the appeal when you appeared in front of the examiner?
Excuse me?
I noticed you appeared in front of the examiner as well, and now you're doing the appeal. Is that normal? I don't know how the system works.
I guess because I do most of the appeals, I'm going to get my own cases in there, but I've generally follow most of my cases all the way through, but I also do a lot of other cases from other hearings. which has actually given me a good reading of a lot of different superior judges that I've never even been in front of, because I see their decisions, but, so I get a sense of who they are that way. But no, I pretty much handle most of the appeals at this point. But I think that'll be changing, so we're getting new people on board.
Oh, wonderful. Well, I just want to say, I mean, you're our next case in a week, both of you. We'll see you again, and especially Ms. Hernandez, we know this is difficult work that doesn't pay what it should, and we are very grateful to both of you for doing this kind of work, without which we wouldn't be able to do what we need to do. So thank you both on this case.
I will say Attorney Hernandez is one of the best at it, and I do call her when she wins. Thank you.
All right, so I want to thank all the attorneys we've had today. I want to thank our clerk. I want to thank our timekeeper. Thank you. And certainly our court officer for the great job he's done. And we will be adjourned until tomorrow at 9:30 a.m. in the Hale courtroom.